I stand on my 2 feet. I'm in my proper person. I am sovereign. I am man. The flesh lives. The blood flows. I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case.
That would be denied.
Along with the officer and sergeant who are already going to be getting sued. There's no need to add you as well.
Any threats to sue me or to take any action against me, I can't be swayed by that. So
It's not a threat. It's just what it is.
Go ahead and have a seat, please. His rights at arraignment.
I've made this special visitation under duress pertaining to the matters of Jonathan Troy, Faifu Leaso Maliatoa Schuster. For I am beneficiary, I am sovereign, I am man. The flesh lives, the blood flows. I am a non-U.S. citizen, American national.
You're watching Adelat Report, where we bring you real cases and real verdicts. Let's begin today's case. Welcome back. Today's courtroom drama features a defendant who starts off by announcing he's a living man with blood in his body, as if the judge had any doubts about that. From there, it only gets worse. He even threatens to sue the judge right there in the middle of the hearing.
I am sui juris imperpio persona. I reserve all rights. I do not understand the status. And so I ask you, ma'am, what is your name? What is your nationality? And what is your status?
I'm Judge Grant. I am a citizen and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last 2 are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I've challenged the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued, it would just add to that. And I don't think that you need to go that route.
While I review this incident report. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the law.
Unless you want to enter a plea of guilty, today there'll be a plea of not guilty. Understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but it looks like you have a driver's license that recently expired.
That's not strategy. That's walking straight into trouble. Then he challenges a court's authority while sitting in handcuffs inside the courtroom, speaking directly to the judge. That's like asking if gravity works while falling down the stairs.
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
All right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating.
Again,
the
I
laws.
was not driving. Again, I have rights.
You were
and
behind. the
my
wheel
rights were
of a car that was
violated.
traveling.
My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am
you.
sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also indication that Mr. Schuster will not abide the court's orders to appear on his promise.
His words sounded like a random mix, with no legal meaning at all. It's also clear that if this man were released, he wouldn't show up again. He treats charges like they don't matter and court dates like optional invites. Responsibility is something he refuses to recognize. At one point, he even tried to negotiate with the judge by threatening a lawsuit, as if this was some kind of business deal.
I want to look at the Seattle Municipal case and see when he's next scheduled to
Like you had
appear.
mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale, Malietoa Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas.
Which have all
The
been cleared
previous
up.
warrants history.
And throughout this process of going to courts, I've had to learn a lot. And so I know it's no game to just not show and make visitations. That's not what I want to do. And again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me, on my own recognizance. Ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I
I
do
don't
not.
see another, I
And
don't see another date set until February 12th of 2025 in the Seattle
In
case.
Seattle Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail, and any threats to sue me or to take any action against me, I can't be swayed by that. So
Well, it's
you
not
can
a
do what-
threat. It's just what it is.
And
Because my
absolutely, you
rights
can-
have been
you
violated,
can
and
do
if my
what you
rights
need
are going to be
do, but
furthermore
you can set
violated.
bail at $2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance.
That's not confidence, that's self-destruction. Many judges would have called him in contempt immediately, but here the judge stayed calm and professional. In the end, the whole hearing was a disaster. He kept repeating the same empty lines, thinking they would magically erase his charges. But instead of helping, his approach just made things worse. The judge never lost composure, but honestly, it was hard not to laugh at how badly this man was sinking his own case. What do you think? Was the judge too patient, or was she right to let him keep talking? Share your opinion, and if you want more real cases like this, don't forget to subscribe to the channel.